Choosing the right name for your trust is more than just a formality. It's a critical legal decision that affects how your assets are managed, transferred, and protected. A properly named trust ensures smooth financial transactions and clear legal identification. Every trust must have a unique name to hold and transfer assets legally. This name becomes the official identifier for all property, investments, and accounts held within the trust. Without a proper name, financial institutions may refuse transactions or delay asset transfers. Trusts generally fall into two main categories. Living trusts are created during a person's lifetime, allowing them to transfer property into the trust while avoiding probate. The person who creates the trust, known as the grantor, may serve as trustee or appoint someone else to manage the assets. Testamentary trusts, on the other hand, are established upon death through instructions in a will. These trusts often provide for future beneficiaries according to specific terms set by the deceased. Living trusts can be further classified as revocable or irrevocable. Revocable trusts allow the grantor to change or cancel the trust at any time. While these trusts don't go through probate, the assets remain subject to estate and income taxes. Irrevocable trusts permanently remove assets from the grantor's estate. The trust itself pays capital gains and taxes, and upon the grantor's death, these assets avoid estate taxes. This structure offers significant tax advantages, but less flexibility. The trustee plays a vital role in managing the trust. Their responsibilities include protecting and collecting trust assets, handling tax obligations, maintaining detailed records, and overseeing investments. Trustees must balance current beneficiary needs with future growth, always acting with integrity and following the trust terms exactly. Before finalizing your trust name, you must ensure it's available for legal use. This availability is crucial for properly titling assets, avoiding conflicts, and ensuring compliance with financial institutions and tax authorities. A trust name serves as its legal identification, making it essential for the name to be unique enough to be distinguishable in legal documents. Banks, title companies, and the IRS all require accurate trust names for property and tax documentation. To check if your desired trust name is available, start by searching county property records where the trust will own assets. While trusts aren't filed like business entities, it's wise to verify that no business or trust with a similar name exists to avoid confusion. Some financial institutions require documentation showing that a trust name is unique within their system before opening accounts or transferring assets. Working with an experienced estate planning attorney can help you perform thorough searches and understand the legal implications of your chosen name. When selecting a trust name, most people use the grantor's full legal name, such as John A. Smith Revocable Living Trust. For married couples, joint trusts often include both spouses' names, like John and Mary Smith Living Trust. Adding the trust's creation date helps differentiate multiple trusts, as in Smith Family Trust dated March 1, 2025. For privacy concerns, you might consider using initials, phrases, or non-family names, such as Sunrise Legacy Trust. However, avoid names that might mislead or imply a business function, like Smith Enterprises Trust. Several factors should guide your trust naming decision. Privacy is important. Using a unique or less obvious name helps maintain anonymity in public records. Simplicity matters too, as shorter names reduce errors in titling and paperwork. Consistency is crucial. Use the exact same name across all documents, titles, and accounts. While you can change a trust name, especially for revocable trust, the process involves more than just updating a document. You'll need to amend the trust document, retitle all assets under the new name, and notify all institutions holding trust assets. This can be cumbersome if many assets are involved, which is why careful initial selection is important. To ensure your trust name is available and effective, conduct a general search online to identify any conflicting uses. Avoid common phrases like the family trust that may be too generic. Instead, use descriptive identifiers by combining a surname and date or a unique word. Never use terms like LLC or corporation that imply business entities and can mislead third parties. Remember these key points. Every trust needs a unique name for legal asset management. The name you choose must not already be in use in your jurisdiction. Trust names typically include the grantor's name and date, but can be customized for privacy. Avoid common or misleading names that could delay asset transfers. If you change a trust name, all titled assets must be re-recorded. And finally, a trust name is essential for tax identification and property titling. Selecting the right trust name is an important step in creating an effective estate plan. With careful consideration and proper legal guidance, you can choose a name that serves your trust's purpose while avoiding potential complications.